Welcome to the Deep Dive.
Great to be here.
Today we're digging into a really significant Supreme Court case. It touches on some very complex issues around competency and the Eighth Amendment.
Absolutely. As you know, we focus on summarizing key Supreme Court arguments, and this one, it posed some fascinating questions.
Yeah, the core of it was whether someone with severe dementia, who actually can't remember committing the crime they were sentenced to death for, is still competent to be executed.
Right. The court really had to grapple with that. Let's unpack the arguments that got them there.
Okay, so stepping back a bit, the case really boiled down to two main questions before the justices, didn't it?
It did. First, you had the issue stemming from precedent cases like Ford and Panetti. Can someone who, just doesn't remember the details of their crime still be considered competent?
Even if they technically understand, the basic fact that they are going to be executed for a capital crime.
Exactly. That was the first big hurdle. Does that memory gap matter under the existing legal standards?
And the second question?
That was about the condition itself, vascular dementia, that this isn't, typically classed as insanity or psychosis in the way those terms have often been used legally.
So could a condition like that, vascular dementia, still be grounds for an incompetency claim under Ford and Panetti?
Precisely. Can dementia, even if not a traditional mental illness in that specific legal sense, be enough to say someone isn't competent for execution?
Let's get into the petitioner's side first. Their attorney argued that memory loss, especially when it's tied to actual physical brain damage or maybe conditions following something like a coma, that could make someone incompetent.
Yeah, they really push the idea that you have to look at the person's current state, their present ability to rationally understand what's happening.
Not just whether they remember the past crime.
Right. The argument was, how can you rationally understand the connection between the crime and the punishment if the crime itself is gone from your memory due to a medical condition?
And they brought some pretty stark examples of the petitioner's condition to the court, didn't they?
Right.
To show this wasn't just, saying, I forgot.
Oh, absolutely. They pointed to things like a memory score of only 58, which is extremely low.
And not being able to recall the season or the month or even the day of the week.
Yeah, and struggling with something as basic as reciting the alphabet apparently couldn't get past the letter G. These details really paint a picture of severe cognitive decline.
So the argument became, if you're that impaired, if you genuinely can't recall the circumstances of the offense because of this documented decline,
then you can't rationally understand why you're being executed. But importantly, the defense lawyer did concede something too.
what was that?
They agreed that simply saying, oh, I don't remember, wouldn't cut it. You couldn't just claim amnesia without a real underlying medical cause.
Right. It had to be linked to something concrete, like the dementia diagnosis.
Exactly. Now, the state's argument was interesting because it evolved. Initially, their position was pretty rigid. They argued that incompetency to be executed could only be proven if someone showed signs of insanity, delusion, or psychosis. Those specific categories.
So dementia wouldn't have fit their initial definition.
Not explicitly, but then before the Supreme Court, they actually conceded. They acknowledged that dementia could potentially be a basis for finding someone incompetent.
That seems like a pretty significant shift.
It was. It changed the focus of the debate. Once they conceded dementia could count, the question became, well, what level? What defines severe dementia in this legal context?
So how did they try to define that?
The petitioner's attorney pointed towards the DSM-5 criteria. That's the manual doctors use.
Okay. What does that involve?
It involves looking for clear evidence like signs of brain damage on an MRI scan, and also showing substantial cognitive decline.
Which they argued was shown by things like the big drop in IQ and those memory scores we mentioned.
Yes, and crucially, linking it to a clear cause, what doctors call etiology. In this case, things like life-threatening strokes and cerebrovascular disease. It's a whole picture, not just one symptom.
And they use another example too, right? Something about the prison cell.
Ah, yes, that was quite striking. They described how the petitioner couldn't consistently remember where the toilet was located within his own small 5-by-8-foot cell.
Even though it was always in the same place?
Right. Apparently, he could verbally explain that there was a toilet and what it was for, but he couldn't reliably retain the spatial memory.
Leading to incontinence, they said.
Yes. And that example was used to highlight this gap between sort of abstract knowledge and practical functional understanding and memory, if you can't manage that basic orientation.
What does rational understanding of execution even mean at that point? It's a powerful point. But the state obviously pushed back.
Of course. The state's attorney argued, look, just because someone doesn't remember the specific crime doesn't automatically mean they're incompetent.
They drew a distinction.
They did. They separated the memory of the crime from a rational understanding of the punishment itself, knowing that you are going to be executed, and broadly that it's connected to a past serious crime.
So, for the state, you could lack the first, but still have the second.
That was their position. They also made a procedural point, saying the petitioner hadn't really presented new evidence since a lower court had previously found him competent.
And they questioned the evidence itself.
Well, they argued that while an MRI might diagnose dementia, it doesn't definitively tell you about someone's rational understanding in the legal sense.
When the memory claim itself.
They framed that as inherently subjective, something only the defendant truly knows, and potentially could be faked, although the medical evidence was strong here.
Just as Breyer seemed particularly focused on the broader implications, right?
He did. He raised a really important point about the aging death row population. We're seeing more cases where inmates develop dementia over the many years, sometimes decades, they spend incarcerated.
So he was asking, what's the standard going to be? How do we handle this growing issue?
Yeah, especially when someone doesn't remember the crime and is severely disoriented to basic things like time and place. What does competency mean then?
How did the state respond to that concern?
They kind of fell back on the idea of retribution. They argued the state still has a strong interest in carrying out the sentence for the crime committed, even if the person's memory has faded.
And they kept returning to the Panetti standard.
Yes, emphasizing that Panetti focuses on understanding why you're being executed. The state maintained that, despite the memory loss and disorientation, the petitioner still had that basic understanding.
The state also had an expert witness, didn't they? Someone who'd done many competency evaluations.
They did. An expert who had apparently done around 4,000 such evaluations.
Wow, okay.
And this expert used a standard similar to what's used for competency to stand trial, which involves assessing rational understanding.
And their conclusion.
That expert did not find the petitioner incompetent based on their evaluation, so the state leaned on that assessment.
But the petitioner got the last word in rebuttal.
Right. And their lawyer hit hard on the state's change of position, reminding the court that the state hadn't previously accepted dementia as a potential basis for incompetency at all, not until this appeal.
So pointing out an inconsistency.
Exactly. And they finished by reiterating their central point. Executing someone this severely impaired, this bewildered by their condition
Would be inhumane.
Yes, inhumane, and a violation of the Eighth Amendment's ban on cruel and unusual punishment. That was the crux of their final plea.
Okay. So that brings us to the 10th chair segment. Thinking about all this, putting myself in that hypothetical seat. It's tough.
It really is.
But listening to these arguments, especially as someone who tried to distill these complex legal points, the evidence about the petitioner's cognitive decline is, it's incredibly compelling.
The details are stark.
They are. And while the older cases, Ford and Panetti, they were focused more on, say, psychosis or delusions.
Yeah.
Our understanding of the brain and conditions like severe dementia has evolved.
Medicine changes, neuroscience changes.
Right. And that makes me think we have to reevaluate what rational understanding truly means when someone's brain is demonstrably damaged in this way.
It forces a difficult question.
It does. Because when someone can't recall the very crime they're being punished for, and they're significantly disoriented, and there's clear medical evidence like MRI scans showing brain damage, it feels like there's a fundamental disconnect.
A disconnect from the reason for the punishment.
Exactly. A disconnect from the circumstances, and maybe even for the whole retributive purpose the state talks about. Can punishment serve its purpose if the person receiving it is in such a compromised state?
That's the Eighth Amendment question right there.
Yeah. To me, executing someone that impaired raises very serious questions about whether it meets the standard of humane treatment under the Eighth Amendment. The focus really has to be on their present capacity for understanding, and severe dementia seems to just fundamentally erode that capacity. That's where I land, sitting in the 10th chair.
It's a powerful perspective, and it reflects the difficulty the actual court faced. This dive really shows just how tangled these legal and ethical threads can get.
Absolutely. You've got law, medicine, our understanding of the mind, all intersecting in ways that have, well, profound consequences, life and death consequences.
We hope this exploration has maybe shed some light on the different arguments and the real complexities involved in this case for everyone listening.
Definitely. And it leaves us with questions, too. What are your thoughts on how we should define competency in these kinds of situations? As our understanding of cognitive decline grows, Should the legal standards evolve too?
Are there other factors that should be weighed when the state seeks to execute someone whose mental state is so severely compromised?
Lots to think about. We encourage you to keep pondering these critical issues.